First of all, I'd like to thank Enfold in particular and CSJ, and it's a good beginning in terms of having this discussion on restorative justice in a university and having a collaboration with UNICEF. And it's a one-year journey. Last year I was here, we were here with Sujata and, learning about restorative justice processes and practicing those. Today we have an interesting panel discussion. What is the time limit? It's still 1:15?
Yes, so each speaker has 15 minutes.
Yeah, so we do have up to 1:30. So 15 minutes for each speaker, and then we leave half an hour for discussion, for questions. So we will give time to each of the speakers and to present your ideas. I'll just begin with a formal introduction. I'm not sure whether everybody out here in the hall is familiar. We've had a beginning with restorative justice, since there would be students from the university also. And a lot has changed in the legal system. A lot remains the same also. We have, the topic of the panel discussion is in terms of looking at restorative justice in the Indian legal system. The Indian legal system has changed to a certain extent with the new criminal laws. When we're talking of the criminal justice system, we had in 2005 for the first time the definition of victim being introduced under the CRPC. And that was the first time it was realized that there was this huge gap that occurred in our justice system where the needs of victims were really not acknowledged. And it was the Supreme Court which talked about victim compensation and spoke about that bit of it. But in a way, it was all restricted to monetary compensation. The so-called, under the new laws, there is this great emphasis now that claims that, yes, it's more victim-centric. How it would run out, we need to really see that. But yes, we have, under the BNSS, introduction of new sections also in terms of meeting the requirements and victim having a say in the process of trial and whether to go in for an appeal and all those aspects. So in that way, there is certainly a change that has taken place in terms of reorienting a little bit and changing the gears towards victims of crime in particular. And for the first time, we went beyond, punishment under the IPC was restricted to fine and imprisonment. But under the BNS, just for 6 offenses, we are having the community service. And we will be having one of the speakers talking about that part. It's been it's going to be 1.5 years, rather in July, it'll be 2 years since the introduction and the changes that have taken place. Community service orders and how they can be combined with restorative justice principles is something that the Indian legal system is really will have to plan about. There are states which have come out. Delhi came out with the first notification. We are still having that, concern. A lot of us are having the concerns about what kind of community service orders are going to be passed. Whether they're going to be actually restorative or not is a question mark, and how they will run out. Do we have a system similar to sometimes what appears on paper, like let's say the Probation of Offenders Act appeared fantastic in terms of restitution, in terms of reducing the harms, but how it has panned out is something totally different. So similar concerns, I guess, a lot of us have about the community service scheme as well. And the whole, we're talking about restorative justice in an era of punitiveness and in an era where we are talking of more deterrent laws, seems to be a little bit out. But at the same time, we Indians are very good at reconciling dualities in certain ways, I would say. In the previous session, they were talking about not having the term justice itself, but you had the statue of justice being inaugurated, and the statue is whether it should be blind or not blind is another question I have. you know, if the justice is blind, you ignore the needs. And the whole framework of restorative justice is looking at justice and feeling justice. It's not who has done the crime, it's who has been harmed. And what are the needs of the person who has been harmed, and whose obligations are those to repair that harm. And it's not just one person who's affected, it's a whole community that is affected. So whether we are having all the stakeholders in the justice system and how it would run into the Indian legal system with power differentials in particular, that are a challenge that we will have to meet over the years. And it takes about more than a decade actually for the laws to become effectively implemented. We've seen that with the Juvenile Justice Act, we've seen that with POXO and with POSH laws. So I always say that it's easier to change and amend the laws. I've been a part of committees where we have framed the rules, regulations, and even the laws. But to actually implement them and have the spirit of that implementation being run out is something that requires a lot of sensitization of the people who are going to be a part of that process. So conversations start, and this dialogue and this panel discussion is something that I've been looking forward to moderating and hearing from the different perspectives, because dealing with both POSH complaints as a member of the ICC in various government setups and the universities, looking at probation law and looking at forgiveness as a psychologist, I mean, how do we, because one of the fundamentals at times has been that forgiveness may not happen in restorative justice. It's not essential. I learned that from Brian Steels, who's an RJ proponent in Australia, that no, I cannot forgive, but at the same time, I have moved on. And I've heard from a survivor of violence, sexual violence, who encountered her rapist, and saying that at first, she did not really forgive, but later on, she moved on, and that healing that happened. So restorative justice values, as have been put in the room, are something I think they are very fundamental to this whole movement. And whether those values get embedded into the legal system is again, and how do we embed them, is something that has to be worked out. And it's going to be a constant process. So I can already, I mean, in terms of when we look at the possibilities are there under Article 21 when we talk in terms of the right to dignity, right to live with dignity, which is a fundamental right of every individual. So everything flows in from there, and you have the court interpretation for that. But at the same time, you know, you are wondering also, when we look at the limitations, at how that gets interpreted. And acknowledgement that, yes, it took about 47 years for the Supreme Court to acknowledge that it had done harm in not acknowledging about the case in the Tukaram versus State of Maharashtra case, about the harm that came to the victim, and about acknowledging that, yes, she was raped, it wasn't her fault. And I think that institutional acknowledgement becomes important, even if not as a form of apology, but just realizing that, yes. But as I said, that there are a lot of dualities that we Indians have. At the same time, the Supreme Court has ruled out that political parties will not be covered under POSH because there could be this concern of false complaints. So that's another thing that a lot of it comes about. So I'm just laying down in terms of my ideas that when the speakers are speaking on these topics, to also address some of these things, and for the audience in general. And of course, with Asha, I mean, I've had the good fortune, and I always say that, you know, when you're thinking, कायनात जो है इस तरह से आती है कि सब चल जाता है, so it's like quantum physics, because your thoughts have an energy. And I was thinking in the morning that, okay, Asha I know slightly, and she was there in the same hotel that he was staying in. I did not meet Namah and Diana. And when we were having this ice-breaking round in the first hour, so we had a good conversation. I've had a good conversation with all of them. And it's important for me to know my speakers and to know them personally a little bit. And that makes the dialogue and discussion much more interesting and much more intimate as well. So looking at that part where India has moved on to a little bit of a victim's perspective, and while we have also, we are learning as well from different countries' experiences, I think we have our own indigenous ways, and it's not something new. Restorative justice has been there with us when we talk about panchayats. How lok adalats have run out is a totally different story. But yes, the roots are there in our Indian ethos, in our religion, and in our spiritual and cultural considerations. So we have I think I've taken that time in terms of the introduction. So when we're looking at the principles and legal dimensions of restorative justice in the Indian context, the possibilities are there not just under the criminal law, but under the special laws also. Whether it is POSH, whether it is domestic violence, and whether we are looking at also different areas and aspects that have not yet been touched upon, but are being debated is in terms of how do we compensate victims of wrongful accusations of crime, and another part is in terms of looking at also crimes of hate that are there. And some possibilities that we have is in terms of the Indian legal system, I feel, is opening up. You're talking of mediation. So we have alternate dispute resolution being embedded into the legal system, and being an area where a lot of focus is being given. But ADR is not restorative justice, and sometimes mediation and restorative justice gets confused. So they are totally two different things, but certain aspects remain fundamentally common. But at the same time, it's restricted to the legal part. But restorative justice is not just the legal terminology. So I think that part of the terminology and the language, but beyond the language, I guess I always strike down to what are the values, and whether the questions that we need to ask at the end will remain fundamental as such. So the first speaker that we have is Namah, who will be speaking. So Namah, we look forward to hearing from you.
Firstly, I'd like to take this permission from you all that I would be seated, because actually I took a terrible fall yesterday. So I'm really slow. So I don't think I'll be able to stand for that long. Now, I have been introduced. Thank you so much for that introduction. I would also like to thank this organization and all the organizers who have come up with this effort to talk about restorative justice. It has actually given me and my team an opportunity at SettleWise now to discuss, how special laws interact with and how they can incorporate things like mediation to encourage and promote restorative justice. Today my paper is Peace with Purpose, Reimagining Conciliation as Restorative Justice through the lens of mediation under the POSH Act. Now, before I go on into talking about what this paper is and how this paper, I've presented the ideas and how we have proposed this new solution to looking at Section 10, I would firstly like to say that this comes from my own personal experience. From my third year from my law school, I had been mediating. And because of my experiences in, local college mediations and at the local college level, I was given the opportunity to sit for the Internal Complaints Committee, which is now known as the Internal Committee of my college. Throughout that experience for 2 years, I noticed a lot of patterns, which is what eventually led to this idea. Now, as Meghna ma'am had also mentioned, that Section 10 talks about conciliation. And it talks about how the victim and the offender, or we can even call them the complainant and the offender, can come together and have a settlement. However, that settlement should not at any point be a monetary settlement. While the intention is very good on paper, as ma'am has already mentioned, it is rarely ever seen to be effective. And that is what I have tried to reimagine by bringing out mediation. Now, when the Vishakha guidelines have come into place, Vishakha guidelines brought in the POSH Act, because they indirectly brought in the POSH Act because they spoke about the guidelines of how workplace harassment needs to be dealt with. The Parliamentary Standing Committee report has been a very important aspect of my doctrinal research on this subject, and that has been to see that the Standing Committee report has said that Section 10 very clearly is giving the complainant a chance to speak on what she has gone through. And if she believes that there is a possible settlement, then she can control the process. So the reason conciliation was mentioned and probably not mediation at that stage was because they wanted complete agency to be with the complainant. Now, however, with the Mediation Act 2023, we can see that the definition of mediation has become conclusive and inclusive of the word conciliation also under the umbrella term mediation. So there is already a first step that has been taken, that conciliation and mediation have been brought in together to bring a harmony. Now I divided this paper into 7 parts. The first part being the introduction and the last part being the conclusion. My main focus starts from the second part. In the second part, I analyzed Section 10, and I spoke about in detail of a case, Ranjit Benipal versus Bhabha Atomic Research Center case. So in this case, they noticed that the importance of Section 10 is to see to it that the complainant's informed consent is there. What often happens, and this is a big disadvantage that has been seen, is that the IC comprises of members from the very same institution. Now, this is something that we've spoken about, that it is a power imbalance at its very core. So at that power imbalance, I as a student member, for example, I was a student member of that. So if any complaint were to come against other students, would I be in a perfect position to conciliate the dispute? Am I trained enough? Do I have the gender sensitivity training in question? So questions like this come, and this is where I believe that Section 10 is silent. If you notice, Section 10 says that the IC is to act as the conciliators and see to it that there is some kind of a facilitation of a solution. But there is no clarity onto how the IC is supposed to govern this. The POSH Act is a very good first step to talk about in such great length and detail as to what it can look like, what a solution can look like, how the IC is supposed to function. But it is in Section 10 that it is utterly silent on what the IC is supposed to do. Are they supposed to push? Are they the ones who are supposed to suggest a conciliation? Is it a procedural obligation that there has to be a conciliation? Which is why we have to look at case laws like Ranjit Benipal case, wherein they had said that it is more of an obligation of the IC to tell the complainant that she has this right. However, it is not upon them to force this on that complainant. So that is how we've analyzed Section 10. My team has seen that there is a fundamental gap here, and there is a lack of procedural clarity as to how the IC is to function. Now, the next part focused on the link between conciliation, mediation, and restorative justice. As ma'am has already greatly pointed out, that mediation is not restorative justice. These are two different concepts. However, mediation does imbibe certain concepts of restorative justice within it, so it can maybe come under one of the terms under the umbrella, the larger umbrella of restorative justice. Conciliation too was thought to give a lot of agency to the complainant. However, now the way that I see it is that mediation can offer an escape from the IC. Why I use the word escape is because in several organizations, the IC fails to meet basic standards of, let alone restorative justice, they fail to meet basic standards of even a fair and not biased committee. That is often lacking. So because of that, we suggested and we noted out the differences between conciliation, mediation, and restorative justice. And we focused on how mediation can be the appropriate solution. Now for that, in the fourth part, I focused on, and this I will just touch briefly upon, we touched upon a comparative analysis of how internationally the international jurisprudence says that this can be done, that there is the option of giving the employee who has faced any harassment or any, has suffered any sexual harm, the chance to approach a trained mediator outside the ambit of the organization that they're working in. So this has been done in the United Kingdom through their ASAS, which is the Advisory, Conciliation and Arbitration Services. It has also been done in New Zealand, and it has also been followed through the system of victim offender mediation, which is which is practiced in 18 countries. Now coming to beyond this system of restorative justice and how, they've incorporated mediation, comes the fifth part, which is acknowledging systemic barriers to restorative conciliation as it is now. Very often there are cases wherein there is a language barrier. As again, Meghna ma'am had pointed out, that it is not always necessary that we see very major offenses coming up. There are minor offenses also. So it is seen that if mediation is brought into this solution, we can encourage more victims, more complainants to come forward with even minor offenses, wherein they won't feel that they're being penalized for just coming up and talking about their own stories. Because there will be a dialogue that will be enforced to bridge a gap. It'll see to it that things which are coming out from, lack of knowledge, lack of, a language barrier existing maybe, all of these can be acknowledged through a dialogue that can be enforced better by a trained mediator than conciliators who are prone to their own biases. Because as a student of the same organization, another student comes in, I already have personal stories, things that I have heard, so I cannot absolutely be thought to be of as neutral as they want the IC to be. Coming to the solution, I've imagined it as a 4-part stage. The first part would be, so it is to acknowledge the scale of damage. So for that, the 4-part process starts with the first, which is pre-mediation counseling. Before we approach this matter into, through mediation, we have to see whether or not it is appropriate. So the standing committee report, the 239th report, had mentioned that this should not be used for grave offenses and it should be used for more minor offenses. So for that, this is the first part where the IC can do their role here and they can see whether this matter is fit. Whether it is if it is a criminal form of the highest order wherein there's been something which is absolutely grave and damaging and the complainant is not comfortable to even discuss conciliation, mediation, etc., then there is no point going ahead and wasting the time of everybody involved. It is better to go through the IC mechanism. But on the other hand, if it is a minor offense and if the complainant herself hears that, okay, there is this option that she can take up, mediation services and it will be dealt with somebody outside the ambit of the organization, as I've said, then they can do, then they can, in their pre-mediation counseling, affix that this is a good, appropriate case for mediation. The second would be the neutral facilitation, which will be carried about by trained mediators, which will be a third party, which can be third party organizations. We have several private organizations working throughout India who can be hired for these services, who can be outside that employer relationship and who can see to it that there is no bias, that the process is with informed consent. There can also be there can be a recheck, checks and balances. Our system of law is also one of checks and balances. So it can be rechecking that yes, there is informed consent of all the parties in question, especially the complainant. The third would be the restorative outcome and the documentation. This is in case that there is a settlement, if there is clarity and if the complainant has gotten what she wanted out. Because justice is what the complainant, what the person who has suffered harm wants from the process. It is not what you and I envision as what should the solution be. So a mediator once has guided, the complainant throughout this journey, then you can document whether or not you have reached to a settlement. And lastly is the post-process accountability and follow-up, which is where I imagine it to be handed from the mediator or the mediators back into the IC to see to it that there is a follow-up. So if there is this admission of guilt and there is this, that I will fix my behavior on behalf of the offender, then that follow-up cannot be done by the mediators because they cannot keep coming into, this particular matter and chase it through 1 to 2 years. So it is that post-follow-up best is done by the IC. So that is how I've imagined. So in conclusion, I really believe that conciliation was thought out with a very good idea, but its implementation has several, issues, systemic barriers to it. So reimagining it through a process of mediation would be a very constructive and good approach. Thank you.
Thank you so much, Namah. You have given the interpretation of Section 10 of conciliation under the POSH law. While dealing with complaints as an external member, sometimes the request also comes from the complainant, not at the first stage, but much later. And I recall in one case, I said, we must consider the needs. So you don't go as per the law only, but yes, if the lady wants, if the complainant wants later time that yes, I don't want him to get into trouble. I just want that acknowledgement that he's done wrong. So I think that kind of a flexibility is also something that a mediator should also be looking at. And it's fundamentally the question of, what are the needs of the person who's complaining. And there is that, when you're saying that it is the duty of the IC. So the IC, and a lot depends also on the members. And one of the challenges and limitations is always on how trained are the persons who are dealing with these complaints. Is it perfunctory that you're dealing with a complaint, which is the normal routine I see in the government setup in particular, but also in the private sector? And this is something that when we are looking at that, yes, we have framed this law and we are doing this and every compliance is there, we have this committee. But also it becomes important that the person, the complainants, and everybody, how the complainant gets dealt with, even in your universities, I've seen that. It sends a message down the line. So you may have the others not ending up complaining if they are being victimized because they see one case, one complaint not being dealt with fairly. So it's that whole ethos, I think, that again comes down to what are the values that when you are setting up this committee or when you're having this law, what are you wanting? Is it just ticking the boxes that yes, you have a committee in place, you are meeting with the compliance, or is it really you want to make these safe places for the work environment for women in particular, but also at times when men also say that, and transgenders, you're going to have that whole aspect. So you have shared your insights and your observations, and we will move on to the second session. Of course, anyone who has questions, you can note them down, which we'll have them after all the panelists have presented their ideas. So thank you so much, Namah. Let's give her a round of applause.
Thank you, ma'am.
And now we have Professor Asha Mukundan, who will be speaking about probation and about community service. Both these are areas that need to be in focus.
Thank you. My heart has just been going a little bit fast because when we talk about these concepts, we very clearly need to know that there are two systems here, the criminal justice system and the juvenile justice system, and where are we using these concepts that makes a huge difference. So in the morning when I heard the word mediation, my heart skipped a beat, and I think my thoughts were just like you have written it down as well, because we really need to have a lot of dialogue. Mediation and restorative justice cannot be used synonymously and not in public forums, and we should be very careful about when we are making statements. And in the morning when I heard the statement saying that mediation and we have spoken to the Supreme Court, and I was like, what is happening? Hello. Having said that, I'm coming back to the whole topic of probation and community service and I'm going to speak about this in this context of restorative justice, which is a new concept. It's not a new concept. It's always been there, but in India we have started talking about it. And I believe that we should be talking about it now, because if we start talking about it like Swagata said, after 13 years we are here, right? And maybe after 10 years we'll be, 3 steps ahead. So because the movement in the criminal justice system and the juvenile justice system is extremely slow. And we are just doing back and forth, and that's why I would like to talk about probation in the juvenile justice system, because probation has always been in our system, but it has gone incognito. It's not been spoken about, it's not been seen, and so much so that the word is being used synonymously to probation officer, right? And probation officer and probation are 2 different concepts. And the Juvenile Justice Act, unfortunately, has made a mess out of it. And we need to start talking about it so that, again, if we start talking about it now, maybe 5 years down the line, somebody would hear us and things might be set in place. Probation is a global concept. It's a concept which is we call it non-institutional, it's extremely rehabilitative, and it's also a concept in the adult system which says that that's the only system right now in the adult system where if a person gets probation, they will have no criminal record, right? But how is it panning out in the juvenile justice system is something that we need to understand, because the concept of probation, whether used in the criminal justice or in the juvenile justice, should not change, but it has changed. And we are not talking about it. Nobody is even talking about it. And that's why I am going to speak about it here. One, probation, like I said, is a non-institutional service. It's a rehabilitative process. And if you look at the 7 orders that are being passed in the system, probation comes in twice, where you give probation under a fit person, you give probation under a probation officer. And probation technically is only for the offending population. But unfortunately, in the juvenile justice system, we have used the probation officer randomly for all the purposes. And that may be, according to me, a wrong number, because there is a sanctity for every concept that we are talking about. So in the adult system, under the Probation of Offenders Act, probation officers are appointed. It has always been that those probation officers were the people who were working with the adult system and the juvenile justice system. There always has been only 1 or 2 probation officers in every district. Highly understaffed, because if you say 1 or 2 probation officers looking after the entire criminal justice system and the juvenile justice system, it's practically impossible for the probation officer to look after such a huge workload. But it has been happening. In fact, in some states, if you see, there's 1 probation officer for 2 districts. 1 probation officer for a couple of districts. So there are, nobody is talking about it, and the role of a probation officer here is a permanent government officer. In many states, he's a class 1 officer. In many states, it's a class 2 officer. And that makes a lot of difference, because a probation officer is a friend of the court. And when they go and speak to the magistrate or the judicial system, there is a little bit of power dynamics that do come in, but there is a sanctity that you're a gazetted officer, you're a class 1 officer, you're a class 2 officer. The judicial officer also finds it comfortable to talk to a permanent government staff. Having a permanent government staff is very important in the juvenile justice system, because we cannot run a juvenile justice system with contractual staff. A person who is appointed for 1 year on contractual basis has no security of his own job security. How will that person even work to mentor a child who is put under his or her supervision for 2 or 3 years? So it doesn't work in that sense. But that's how the system is now functioning. If you look at our juvenile justice system right now, we have a whole juvenile justice system and we have a whole mission Vatsalya. Ideally, it is the juvenile justice system that should run the mission Vatsalya, because mission Vatsalya is a scheme. But if you look at it in terms of implementation, it almost looks like the mission Vatsalya is now running the juvenile justice system. There are two parallel systems that are coming to play, and that should not happen. The whole juvenile justice system today is functioning on contractual staff. That is an indication to say our system has broken down. And probation officer was the only system that was a proper post. Unfortunately, that post also has got diluted over a period of time. How? I'll tell you. One, the definition of probation now, probation officer in the juvenile justice system is now an officer who is appointed under the Probation of Offenders Act, or a legal cum probation officer appointed under the Mission Vatsalya scheme. Now, a legal officer and a probation officer are two different people with two different skill sets. And unfortunately, again, Mission Vatsalya has said that the legal cum probation officer has to be a person with a law degree. Now, you have a person with a law degree who is supposed to mentor a child and look after rehabilitative requirements of a child. Now that's not the if you look at a law course or the law syllabus, that's not what they are taught. They are taught how to protect the case of the child at every cost. They are not worried about the child. They are not taught about skill sets to rehabilitate the child. In law, you are taught skill sets to protect the legal case of a child. In the whole degree of social work, you are taught skill sets of working with individuals, working with groups, working with communities, which is the skill set that you require for rehabilitation of children. Also, in the whole syllabus of social work, there is also a component of law. So law is also taught to social work students. So that is the right composition for the profile of a probation officer who with social skills and legal knowledge. And it should not be legal skills with social knowledge. That is a complete wrong number according to me, and that's how it is functioning right now. Now we have lawyers who are legal cum probation officers, and they, if you speak to them, are struggling to understand what is their role and how is their education actually benefiting this whole process of working with children. Yeah. So having said that, I'm going to talk about one more two things because they've already given me a heads on. So I've spoken about probation. I'm going to talk about community service, which has come up in a very big way right now in the BNS. And they're talking about how, it's applicable only for a few offenses. But community service, now if I see Haryana has come out with a government notification on community service, and it has mentioned Bharatiya Nyaya Sanhita and the Juvenile Justice Act. Now, what is interesting about this whole community service is it has not one single mention of the word probation officer, right? I don't know how do you have a community service order? How do you give a child community service without supervision of a probation officer? And they have given many people who can supervise the child, but the name of probation officer is completely missing, which talks about how invisible the probation system has now become. And there is the last point that I would like to mention. Probation, like I said, has always been a non-adversarial system is supposed to be a non-adversarial system globally. But the JJ Act has one section that if the children's court gives any order, then that system will become adversarial. Right? Now, nobody is even talking about if a children's court gives a probation order, will that order be adversarial or non-adversarial? Because under the Probation of Offenders Act and under the spirit of probation, it should be non-adversarial. But Juvenile Justice Act is a special act. So will this override the spirit of probation? Is something that we need to start getting into dialogues. We need to start talking about probation, and we need to start saying that, in this whole, we keep saying juvenile justice system is a socio-legal system. It was this probation officer who maintained the social within the socio-legal system. Now with the probation officer disappearing, a law officer becoming a legal probation officer, the Juvenile Justice Board comprising of 1 magistrate and 2 social workers, and if you see the composition in your respective districts, the 2 social workers will be law graduates. Because the government believes that you need to have a law understanding, so they appoint the social workers also as law graduates. So we have a bench of 3 people there with law understanding. We have you have a private lawyer defending the child. You have a PP. Where is the social work component now in the juvenile justice system? Lost. We have lost the socio in the socio-legal system. I think it's time for us to talk about it and bring back the socio by bringing back and strengthening the probation in the juvenile justice system. Thank you so much.
Thank you, Professor Asha, for highlighting the lacunas that exist in the current system, juvenile system, and the probation system. We have our last speaker for this panel discussion, speaking about forgiveness. So, Diana.
Ma'am, I like to present actually.
Look at your presentation.
Greetings to everyone. Actually, I'm overwhelmed with the thoughts that I have heard today, and I'm deeply honored to be here to present my paper, which is Beyond the Harm, Forgiveness as the Catalyst for Restorative Justice. And I'm again honored because I got to work with my supervisor on this paper, Dr. Beulah, Shekhar, and unfortunately, she is not present here today. So I would like to just ask a very simple question. When was the last time when you asked for apology? Or maybe you forgave someone, like, do you recall that? Okay, I can see some heads nodding. So before we jump right into it, I would like to just say a few things. When I was working on this paper, I came across this thought, which is forgiveness the true embodiment of human face? Or is anger the spiriting force of revenge? Is justice the true replica of punishment, or is it merely a facade? And that got encountered when I came across this quote by none other than Howard Zehr, which was, if in doubt, do not pain, inflict as little pain as possible. Look for alternative to punishments, and not only alternative punishments. So with this, I would like to talk about that the criminal justice system has a blind spot. It knows punishment, it knows procedure, but it does not know healing. It does not know the true meaning of it. Sometimes it's just about doing the job. In the end of the day, we all have to go homes. But we are just simply losing the meaning. So the gaps are usually, apology is really structured, forgiveness really studied, reintegration really prioritized, because after all, it's all about getting the thing done. So the purpose is just to understand how genuine apology activates moral accountability, how forgiveness becomes emotional healing, how both together enable reintegration, how psychology and criminology create a unified restorative justice model, how India can embed forgiveness into justice practices. So for that, I've gone through the psychological foundations. The forgiveness models that were used were Enright's process model, Worthington's reach model, and McCullough's motivational model. So they talk about empathy, emotional regulation, cognitive reframing, meaning making. So now going ahead with Enright's forgiveness model, it talks about uncovering the anger, which means acknowledgement of the sentiment. Then decision phase, deciding whether we really want to forgive the person or not. Then work phase, that is when the empathy comes into the picture. And then the deepening phase, the actual work, the real outcome. Then is the REACH model by Everett Worthington, which is actually an acronym, talks about recalling the hurt, that is understanding it, then empathizing, then altruistic gift, which talks about selflessness, committing, and lastly, hold. And followed by McCullough's theory, which talks about forgiveness involves reduced avoidance, reduced revenge motivation, increased benevolence. I guess at this point we might have come across the thought called, I might forgive, but I might not forget what that person has done. So those kind of things we are trying to target here. So then in criminology, I have taken here Zaher's paradigm and Braithwaite's reintegrative shaming, Walker's moral repair framework, and they talk about accountability, dialogue, moral acknowledgement, reintegration. So Braithwaite talks about condemning the act, not the person. Shame plus integration may reduce reoffending, something that is usually seen in juvenile cases, and then encourages acceptance plus accountability, whereas Zaher talks about while crime is basically violation of people and relationships, and justice is all about making things right, which is restoring the balance. And Walker's moral repair talks about crime breaks moral trust, apology acknowledges violation, accountability restores moral equality, forgiveness rebuilds moral relationships, that is, justice equals to repaired trust plus renewed dignity. So here, psychology explains forgiveness, criminology explains restorative justice, and restorative justice explains mediation. And again, we have talked about that it is not purely mediation, but it does embody some of the principles of it. So the methodology that I have gone through, it is actually qualitative, conceptual, and content analysis. And for that, I have used Brown and Clark's 6-phase framework to identify, refine, and organize themes across psychological and criminological literature. So here I have gone through 10 open access review papers, 5 from the domain of psychology, 5 from criminology. And the ultimate aim was to build the apology, forgiveness, reintegration model. So here is how the coding usually looks. And this is one of the papers that I have taken. So the key themes that were identified: apology, emotional regulation, empathy, cognitive reframing, victim-centric needs, which is really important, reintegration, relational repair, moral repair, healing justice. So now here we are looking at the psychological papers and their thematic matrix. So you can see 5 of the papers in the columns and the themes in the rows. So here you can see with paper 3, Macaulay, he talks about motivational shift enables emotional release. Cognitive reinterpretation lowers desire for revenge. When we say cognitive reinterpretation or cognitive reframing, we are not talking about not at all acknowledging what happened, what were the facts. We are simply saying just change the narrative. Don't let that one incident or one thing define your whole life. So in moral repair, we can see victims need moral validation and accountability. Then victim-centric needs talks about motivational model begins with victim hurt, strong victim-centered humanistic orientation. And here we are looking at the chronological integrated thematic matrix. So here Harris talks about core mechanism for reintegration is apology. Then reintegrative shaming reframes identity. Mediation helps victim reconstructing meaning. Offenders reframe harm through guided dialogue. And here in social reintegration, we can see victim of offender mediation leads to community acceptance. Mediation prioritizes victim narrative. So the main themes that I've interpreted here the emotional acknowledgement and victim validation. Across both psychological and criminological papers, apology consistently emerged as an emotional recognition of the victim's pain. Psychological papers emphasize empathy and emotional processing, while criminological papers highlight acknowledgement as moral starting point of repair. Then cognitive reframing and meaning reconstruction, that psychological models repeatedly discuss reinterpretation, letting go, and cognitive shifts, essential for forgiveness. In criminological texts, reframing the narrative of harm supports reintegration. Then we have moral accountability and responsibility taking, which is criminological papers emphasize accountability as a social and legal requirement, whereas psychological texts frame it as an internal moral transformation necessary for forgiveness. If the person is asking for apology and the person is also willing to forgive, then there is a bright start. So empathy, activation, and humanization of offender. Psychological papers report empathy-based forgiveness processes, whereas criminology reveals that mediation encounters human offenders and reduces punitive desires. Then apology as a moral repair. All criminological papers highlight apology as a ritual of moral repair, and psychological models discuss apology as a trigger for emotional release and willingness to forgive. So then we have another themes, which is forgiveness as emotional regulation, shame recognition, reintegrative processes, relational repair and reconciliation potential across both domains of apology, both domains of psychology and criminology. Apology and forgiveness repeatedly appear as catalysts for reconstructing strained relation dynamics. And then community reintegration and social restoration. Both the papers highlight reintegration as a justice goal. And lastly, all the papers converge on the idea that apology and forgiveness create psychological transformation and social transformation. So here is the main thing that I really wanted to highlight, which is apology, forgiveness, reintegration model. So apology is on the offender side, which talks about the moral acknowledgement, where the offender takes the responsibility, recognition of wrongful act, acceptance of responsibility, expression of remorse, validation of victim's harm, invitation to dialogue, which is actually about empathy, trying to understand the victim's perspective. Then is forgiveness as emotional healing, victim's healing layer, which talks about emotional regulation, cognitive reframing, empathy activation, meaning making, release of anger and resentment. Lastly, the community part, which is reintegration as social repair, social reintegration layer, dialogue and relational repair, restoration of trust, mutual recognition of harm, behavioral accountability, community acceptance, and reintegration. One thing that you may notice that in the apology model, which is for the offender side, it is talking about criminal justice system and psychology being the part of it, like the passive part of it. And if you look into the victim healing layer here, psychology is the active part and it's playing in the whole backdrop of criminal justice system. So moral entry point plus psychological healing leads to social restoration. So here are some of the policy implications that we can try to adopt for India in a more nuanced manner, I would say. Mandatory apology protocols, restorative justice training for mediators, trauma-informed practices, victim-offender mediation in selective cases, cultural grounding, Indian traditions of apology, forgiveness, community reintegration boards. So justice is not the punishment of the body. Justice is the restoration of human spirit. Forgiveness is not weakness. It is the emotional engine of restorative justice. So here are some of the limitations. It's just a small data set that I have taken. And cultural variations in apology and forgiveness are not analyzed here. So here are some of the references. And I would just like to add one more thing. That since I'm a student of criminal and victim profiling, I'd just like to add this thing. It feels too weird to acknowledge the fact that when someone suddenly decides the fate of someone else in a quick moment of spur, but yet it feels so familiar. On the other hand, these days, being a victim has become nearly treated as a thin ice, too crusted to point out the tangibility, too thin to serve the truth, and too fragile to bear the opaqueness of the justice system. But it is what we are here to do today. If you might have noticed, I have used butterflies. Butterflies actually, do you know what it symbolizes? Anybody who would like to say? Yes, you're right. It's transformation, it's change. So thank you so much.
Thank you so much, Naina,
for a wonderful presentation and coming up with the AFR model. And you've given the suggestions for the processes also. So we've had three wonderful presenters talking on about three different aspects of restorative justice in the Indian legal context. I'll request all the speakers to come in this half a circle. And we welcome questions from the audience. How much time? So I'll, when we were talking about forgiveness, Diana, it's the part of both the psychology and the criminology part and restorative justice framework. We're also thinking in terms of, both there is this intrapersonal dimension and the interpersonal dimension of forgiveness. It's also important that the intrapersonal part also is important, where the victim may have also to forgive oneself, not inviting it on myself. And that becomes the beginning point of healing also. So maybe when you're suggesting this, you can look at that aspect also of the victim's perspective and the intrapersonal dimension of forgiveness. It's also something, that decision-making part, I think with a lot of survivors of violence, that moment that comes when you decide that for your own healing, you need to move on and you need to let go. And that's the part of transformation of the butterfly that happens, because a lot of times there is that learned helplessness that exists amongst the victims. And this part where you claim that agency again, it begins when you start accepting that yes, and you need to let go, and you are no longer defined by what happened to you. Because we really label. And I think that labeling, whether it's for offenders or for victims, that is the framework that we come up with in terms of what they feel and what they need. So, yes. Just introduce yourself and please ask your question to the respective speaker that you have.
Yeah, I am Harish. I work with the Child Protection Program in Karnataka with the support of UNICEF. I have two questions. It's not the might be the experience. See, we are implementing the DV Act, Domestic Violence Act, where we have mediation centers called Santwana Santwana centers, or the Sakhi one-stop centers, where many of these cases come there. The concept of forgiveness is been mostly because the family members are being brought there, and which is mostly very clear cut of solution kind of thing they do there. But when it comes to the POSH, I am also the member of LC in one of the district, and with the POXO, this thing, the committee POXO cases, where we largely think about the punishment part, not about the forgiveness and other things. So this dilemma we have to clarify through a policy, or we have to brought into the policy or the acts, because the system work on whatever the policy or act says. The way we are talking here, which is we have to wait another 4, 5 or 10 years, maybe decade. We don't know when this kind of reforms will come to the act, because whenever we go to the legal system, we as a evidence victims or anybody who goes there, it is just a process of for a judicial this thing. There is nothing called the justice which we are seeing there. And the second part I want to touch upon this legal come probation officer, that concept. We have Mission Vatsalya where one post for the district, which is called LPO, who largely they are engaged with the official work. There is nothing called probation or even the legal work they doesn't do there. It's whatever the data been asked from the state, they just supply it. Very few of them they go to the building the awareness program. The purpose of whole the mission Vatsalya, that structure itself, it's just giving the a kind of, we don't know, is it a department or is it a scheme, because whatever the objectives are there, which are not been, it's just on the paper, that's all. So these 2 points we have to explore more upon.
Can I just very quickly make think that these words that we are using, no, are very, we use them very loosely. Like even when we say forgiveness, that it's so used so casually in the system. Like just last week, I had a conversation with the Juvenile Justice Board, and the judicial officer, the principal magistrate said, mediation को अंदर लेके आओ, अभी JJ system में बहुत हो गया. Anyways, compromise तो हो ही रहा है. हाँ, victim ने already, offender को माफ कर दिया है. See how words are being used and played in, and saying, तो anyways अगर बाहर से compromise हो ही रहा है, तो आप mediation लेके आओ ना, तो हम लोग legally कर लेते हैं. So I said, is that what you want to do? Because जो बाहर हो रहा है हम कंट्रोल नहीं कर सकते. अगर आप सिस्टम में भी उसको लेके आओगे, डू यू नो यू आर गोइंग टू लीगलाइज कॉम्प्रोमाइज. यू आर नॉट डूइंग मीडिएशन, यू आर लीगलाइजिंग compromise, that whole procedure in the juvenile justice system. And we all know when compromise, when we talk in the legal, in the juvenile justice system, it's most of the time happening for POXO cases. So we need to seriously relook into the words that we are using, especially in the JJ system. It can be extremely devastating otherwise.
Yeah, my question was about the forgiveness part. As far as like we have been practicing restorative practices for almost 10 years, 9-10 years now. For me, the core in restorative practices and restorative justice is also, one is, no power over, but power with each other, values being the core. And more than forgiveness, there is responsibility and accountability taken by the person who did the harm. So without that, without seeing that, but just getting a long letter of apology and then forgiving based on that, no. I need to see some movement. So it can't be apology gotten, forgiveness given, process complete. No. I think we have to be very careful, as you've been saying, the words we are using and how we are using and what we are bringing in as a core process of restorative justice or process. Yeah.
No, we were talking about reconciliation in private spaces. So in companies, it's mostly accepted. It's something that they are okay with. How open is the state to something like this?
So, speaking from the perspective of a government institution, for example, I'll take that one. What happens is that the IC, and this is where it is slightly flawed, the IC sees that there is this provision, which is even there in the UGC regulations 2015. It says that the IC is to encourage, which is also a big responsibility. The IC is to encourage a conciliation. So the IC comes up and informs both the parties that And firstly, when they have a private session with the complainant, they'll be like, there's this option that you have, wherein we'll conciliate the dispute between you and the offender. If she says yes, if she were to say yes, then they can proceed with that process. Now, the problem that happens in such a way is that the state, instead of, and this is what happens in government institutions, at least the institutions that I have seen, especially even heard from, from the experiences, because POSH is confidential as a process. So there is not much of research. It's not like case laws that I can go case law by case law and see what happened, which were the disputes that were, settled and how were they settled. But based on what I have heard and what I have seen myself, every single time, instead of it being encouragement, there is this push, and that push is often with the lack of consent. So what they're going to say is that, beta dekhiye, aap aoge har din, which means in loosely for those who do not know Hindi, you'll come every day, you're going to come here, sit here, we're going to go through this. Are you sure you want to do this? It's better, we'll call him. We'll make him give an apology.
Or also you may be spoiling the future of the student. This is another part.
Absolutely. So now these kind of considerations start coming, that you might spoil the future of the student. Are you sure you want to go ahead with this? Are you sure you want to put yourself through this process? Because no matter how much we keep it confidential, there are chances it might come out. Seeing you here every day also might come out. Bringing in witnesses might publicize this matter. So in all of this, there is this encouragement to settle, and that is not a positive encouragement, that's a forced encouragement. Which is why I said that if they bring in a mediator, what is the difference between mediation and conciliation? Mediation brings in a trained person who's probably informed in trauma-informed practices also. And that trained person comes in, not necessarily holding a law degree, but a person who is trained in the social skills, as ma'am had said, to come in and to help facilitate a dialogue, and that dialogue to reach to a settlement or not to a settlement, and to constantly remind the complainant that it is okay. It is okay if there is no solution here. So that is how I see it. And on the other hand, conciliation through the IC just becomes problematic because they push it. So that is one of the issues that I see in how the state, and this is something that the Parliamentary Standing Committee report had also pointed out, that this is probably one of the things that can come up by encouraging conciliation, that it becomes. And that's why recently the National Commission for Women has requested for removal of Section 10, which will then just take away any such process from the mechanism only.
Which is again wrong, because you are doing away with one of the alternatives. So I think in terms when I'll just mention about some of the concerns that come out, even in terms of, pressurizing the parties to settle the dispute. That's very typical of the agencies within the justice system. Whether it is the police at the Women and Child Support Unit who will pressurize in the terms of mediation, that the parties that, okay, if you register this complaint, that you will not finally, your marital home will be broken. So a lot of times there is that external pressure, that the dynamics that come about. So this is one of the challenges and limitations when we are talking about establishing restorative justice, that just like trained mediators, you need trained facilitators.
This is as a continuation of the same thing. I'm Suja. I'm a consultant in Enfold. I'm also a POSH consultant. So we have had several cases in the government sector where conciliation has successfully been established. And I was part of the process. And conciliation request came from the complainant. And the respondent also was very much in favor of it. And it ended up very amicably. We were able to, in several cases, successfully take forward the conciliation without any pressure. So as IC, we were only suggesting to them that legally this is an option that is available to you. Would you like to take it? And they took it and went forward with it. But as you said, in major cases, you cannot really, may not be the right way to do it. Coming back to your suggestion of a mediation, now POSH clearly says that the IC has an external member who is already unbiased, non-judgmental. So would you still suggest having another person, one more person in the committee who will be a mediator, because there is an issue of confidentiality. And legally, it is not there in the legal framework an option for mediator is not there. So how would you even recommend or suggest having one more person added to the IC is my question, because already an external person is there.
Am I audible? Yeah. So there are several answers to that question. Firstly, it is a policy recommendation on the behalf of SettleWise now that we can incorporate mediation. The mediation will not be, the mediator will not be a part of the IC. So when a mediator, as per the Mediation Act 2023, when a mediator operates outside the ambit of any IC, any such committee. So the IC passes the baton to the mediator. The mediator sits first with the complainant individually. Then there is the neutral facilitation between the complainant and the offender. So that is the first, that is how we imagine it. This is of course something that has to be incorporated into the POSH Act. For this to be a reality, for this to be a reimagination, there has to be incorporation in the POSH Act. Or maybe even through the rules, the POSH rules, there can be an incorporation of expanding the definition of conciliation to have this option for those, especially those ICs which are not trained in the art of conciliation, which are not trained, towards gender sensitive practices, who need some help, who themselves believe that a mediator would be the right fit. So firstly, that would be a policy recommendation. Secondly, coming to confidentiality, the Mediation Act requires that the mediator be confidential. So again, just like the POSH Act binds IC members to not mention any details anywhere, and the same is, not allowed by the Act. It's similarly through the Mediation Act, a mediator is not allowed to do the same. And lastly, if we bring in a mediator, like I've repeatedly said, it just gives that opportunity to see whether or not there is consent. I'm very happy to hear that there are government organizations wherein conciliation is being just suggested and not pushed. But for all those cases wherein it is pushed, the moment we bring in a third party, so the IC member that you said, the external IC member, and this is what again I have seen. Now if you notice, there is this requirement for a minimum quorum for any meeting to happen. It is not always necessary that all the members of the IC are present. And this is what happens, that not all the members of IC are present. Unfortunately, if you have enough women on the IC as it is, without the external member is not needed. And that is why I have seen a whole session and a couple of meetings go through wherein the external member is not needed because they're meeting the minimum quorum. So they just go ahead. And these are the procedural gaps that are, exploited by people. Often the external member is just a token representation. There is just a name. That person will walk in. That person's probably not even that interested. That person is somehow or the other linked to the organization. An ex-member of that organization probably knows the people on the IC already. So there is this question of credibility of that external IC member. There are very few organizations that are actually doing a tremendous job in having a impartial IC.
And it is all subject to if the bill that doesn't go through where Section 10 is completely eliminated, where you won't even have conciliation anymore. Yeah. Quickly, a comment regarding the beautiful way you said where using language is so important regarding forgiveness. We are so actively involved in POXO cases, and we know how when we interact with the children as support persons under POXO, there is a lot of anger, not only within the child, but also the parents. So there is no room for forgiveness at that point because they're going through the trauma, both the family as well as the child. So even any suggestion of forgiveness at that point when they're going through so much trauma and anger and all of that and seeking justice is not something that we ever broach. So it has to come from within, and it takes time. It takes time. There is healing first. Then, after going through the entire healing process is when they sit and ruminate and think of anything remotely close to forgiveness, which is not, I just wanted to add that. Thank you.
Could I just add one thing before, because it's on forgiveness. So we've also been grappling with what forgiveness is and what the role of forgiveness and apologies are in justice, especially when you look at it in an Indian context. It's very different. We are sitting when I'm talking about it, I'm looking at it from maybe a perspective of a woman survivor in a patriarchal setting. And then what does forgiveness mean there? And what is that role that it's playing? Because I did, you did say that, you reconcile, like the reconciliation process is just so ingrained that, okay, maaf kar do aur ghar jao. Especially domestic violence cases, you are seeing that when there's someone who's trying to facilitate, and the role of forgiveness is not the role of forgiveness. It's the role of go back to your house, go back to normal, go on with life. And so in patriarchal settings, in systemic violence and structural violence, we are looking at, even if like we did speak about in the morning with denotified tribal communities and the children there, what is the role of forgiveness and apology then? Who's forgiving and who's apologizing? Who sits across from you and asks for that? When it's a police that's affecting the children. So with all of this, it's none of us have that answer of what that is. But when you look at it in these systems, of course, like what Sangeeta said, there is that role of accountability and responsibility and has to be action-based. But again, that whole thing of when a woman, if I'm looking at it from, and anyone of you can, take this on, a woman survivor, say in a domestic violence case, what happens with apology and forgiveness there when patriarchy is playing such a big role, and it could be her family pressurizing her, it could just be her innate sense to be like, I have to forgive my husband for hitting me because I have children to take care of and I just need to get on. Is she actually forgiving, or is she just going back to what is, feels safer on the other side for her? So that's all of us have been thinking of that. Off late, I think we've had a lot of conversations, but would love to hear any of your thoughts on that.
So this is,
sorry.
running out of time,
Yeah.
so just a very quick.
Is she forgiving or is she asking for apology? Because apology is not forgiving. And that's where reconciliation comes into picture. Apology could just be a reconciliation. It's not forgiveness. Forgiveness is a term which is quite high on the rank of, yeah.
It can't be forced.
Yeah, but that's what, no, we use things like we say maafi mangna means forgiveness, apology mangna yani forgiveness. But no, they are so different. Forgiveness is just up the hierarchy.
Yeah, sorry. Not a question,
The
more
last,
of a thought. Taking all of it together, usage of terminology, words that hold very heavy meaning, heavy weight, and the whole idea of a system being dual in its socio and legal idea of a system that would work well. The idea of healing doesn't necessarily have to be hand in hand with forgiveness. I also see when we put forward the idea of forgiveness, we're again putting a lot of weight to the person who's faced the harm to do the work. And the idea is we shouldn't be putting that much. They are not the ones who need to be doing a lot of the work. It's the community that needs to come together, the person who's harmed who needs to take accountability. Forgiveness may or may not come at a later stage. But I think looking at it through the lens of healing should be priority. The second thing I saw in your presentation towards the end, the idea of mandatory apology. And that sort of startled me because that can be very problematic and that coming back to the whole concept of the system being socio-legal to actually work. A lot of times what happens is when we put these mandatory things in place, they become a checkbox, a checklist that needs to be fulfilled. And that's where beautifully the social workers come into the system, where while we may want to fill a checkbox, we're ensuring that it's not just a checkbox, that the work is actually being put in. And I think where RJ sort of has taken this 12-year journey in the country is a lot of the people practicing it are trying really hard to ensure that we don't become mandatory. While we gain some legitimacy from the system, it doesn't become so ingrained in the system that we have no space for movement. These are not time-bound things. Healing takes time. We cannot put it on a clock. We cannot mandate anyone to feel a certain way or to process things the same way. We're humans, everyone processes and understands things in a very different way. So that
Time is
yeah.
clicking by, so I need to
That's it.
keep that in mind. We've had a wonderful panel discussion with all the three participants mentioning about different areas and possibilities of restorative justice in the Indian legal system, whether it is under sexual harassment of women at the workplace, whether we're dealing with juveniles and probation system and community service, or whether talking about forgiveness. And of course, there are a lot of issues about forgiveness as such, which can't be really forced and pushed. The possibilities are there, the challenges are also there. And we have to be very mindful of the concerns, particularly in a country where we have huge power differentials, where the system, the ideal system may be there in the law, but the implementation part, I think that's the most challenging part in terms of the human element. So whether it's members of the IC, whether it's probation officers, or whether it is judges or JJ board members, the system works as per how they interpret and how they function, as in what are the values. So that becomes important, that when we are trying to establish this framework, we focus also on the human element. And we can discuss the other things, aspects with the respective speakers during the lunch session. I know a lot of you, I don't want to do injustice to your lunchtime. A lot of you may have missed your breakfast as well. So thank you so much for the ideas that you have shared, and for also triggering a lot of thoughts and questions that arise while dealing with these issues of harms and obligations and responsibilities and accountability. Thank you.